My name is Marcy Kiger, and this is my presentation on Bears R Us. Bears R Us is devoted to educating the public on the understanding, appreciation, and protection of grizzly bears. The company was formed by two friends, Pete and Paul, who are not only lifelong friends, they are business partners as well. And they have many things in common, but it was their love and passion for grizzly bears that inspired them to want to share that love with others. They formed an informal business called Bears R Us. Through donations, education, writing articles, and selling books, giving talks, they have seen over $1 million flow through their small business. Pete and Paul have equal responsibilities in the hiring and firing of employees. They make all the decisions together. It's an equal partnership. But after some discussion and with the amount of money flowing through, they've decided to change their business structure from an informal one to one with some more substance to protect their interests and the company. So deciding which business type is a big question for them. They want to protect each other and not ruin their friendship over as something silly that may occur or if any problems arise in the future. So Bears R Us is growing and looking for the right business solution for their needs. There are many different types of businesses, so finding one that meets the company's needs can be very daunting. So we'll take a closer look at a few and compare the options and offerings um, that the business uh, may utilize, and I'm sure they can find one that will best suit their situation. So there are several different types of business plans, and this is a comparison that shows the advantages and disadvantages of the four types of business structures, what each one offers. So I have the LLP, a C corporation, an S corporation, and the partnership. And you can see by the graph that the S corporation and the partnership really don't have as many offerings as an LLP or a C corporation. The one negative thing with the C corporation, though, is that they have to have at least 75 employees in order to form a C corporation. And since their business is already a partnership, transforming it to an LLP, a limited liability partnership, shouldn't be too difficult at all. So after reviewing the breakdown of the different business types, Peter and Paul have narrowed down their options to an LLP or a C corporation. The advantages of the LLP are that it has owner liability protection. The operations are fairly informal. It's much less expensive to start, and there are fewer regulations and compliances that they have to meet. The pros of the C corporation, they may have a lower tax bracket, and they could possibly have people that would want to invest in their company. The disadvantages are self-employment tax may apply, member distributions are taxable regardless of receipt. The cons of the C corporation, it has owner asset protection, it's high cost, many filing requirements. There could end up with double taxation, and they must have at least 75 employees. So even if a partnership is registered, the assets of the partnership remain subject to the claims of the creditors. Consequently, each partner's interest in the partnership remains at risk. It may be a good idea to analyze the assets and decide if any excess are needed for the operations. If not, it would be best to distribute those among each other to eliminate anything that could cause some issues down the road. So a limited liability partnership is a general partnership which registers with the Secretary of State as an LLP. The effect of registration is to limit the vicarious liability of each of the partners. In other words, they would not personally be liable for the debts or obligations of the partnership which arise in the ordinary course of business. So after careful review of the pros and cons, Peter and Paul have determined that an LLP is most suitable for Bears R Us. The key features and advantage of the LLP are: it is easy to set up and easy to manage. It has limited owner liability. There is less record keeping, better profit sharing, and more tax flexibility. So the formal filing requirements, the Colorado revised statutes require an LLP to file a statement of registration, articles of organization operating agreement, and the operating agreement sets forth how the business is to be managed. So all currently existing general partnerships should consider whether registration as an LLP is appropriate. However, the process of registration is very simple. A partnership must change its name to include the words Limited Liability Partnership or the abbreviation LLP. The information on the statement of registration must be typewritten or machine printed. It cannot have any handwritten notes in the columns. Then the registration must include the name and address of at least one individual causing the documents to be delivered for filing. Mistakes on the form could have legal consequences, so it's imperative for all information to be reviewed and make sure that it is correct. Also on the registration, they must provide the true name of the partnership and the entity name of the partnership. There must be a principal office address, the registered agent's information. There must be at least one of the registered agent's names on it, and the individual must be 18 years or older. The registered agent's street address, the registered agent's mailing address, and statement regarding registered agent consent. Also, the individual causing delivery. So pursuant to Statute 7-90-301.5 CRS, each individual causing the document to be filed is responsible for complying with the applicable statutes. So they must provide the name, the first name and the last name of at least one individual causing the document to be delivered for filing. For the tax filing, the LLP entity is not taxed, but the profit and losses are passed through to the general limited partners, and each partner needs to report their income or loss on IRS Form 1065, Schedule K. A limited partner reports his or her share as passive income or loss, and passive income is not subject to self-employment tax, but any passive loss can only be deducted from other passive income or losses, and not from a limited partner's general income. And here is an example of IRS Form 1065 that they would need to fill out. So the admission, the retirement, or the death of a partner. Admission of new members requires the approval of existing partners. Partners can be added or retired as outlined by the partnership agreement, and the LLP can be dissolved by agreement of the partners or upon death or withdrawal of a partner. So a limited liability partnership agreement can prevent dissolution if the partner dies or withdraws. And to liquidate the limited liability partnership, you must file an appropriate form with the Secretary of State, wind up the business, pay all debts, taxes, and claims against the partnership, and settle up any partnership accounts. Upon the dissolution, if the other partners would like to resume business, they would just need to file the registration agreement with the Secretary of State once again. To operate Bears R Us as an LLP will be fairly straightforward. The partners must register the company name with the Secretary of State. They are not personally liable for the debts or obligations of the partnership as a result of negligence, wrongful acts, or improper conduct of other partners. It is a pass-through taxation type of business. The cost of setting up and running the business is not high, and there are no required audits. So the limited liability partnership provides limited liability to its partners. Though personal liability can arise due to negligence, a partner is not personally liable for the acts of the other partner. Internal flexibility allows the LLP to be organized as per mutual agreement. There are no requirements for board meetings or annual meetings, or no special filings or reports need to be made through the business. The filing requirements are fairly easy. They would just need to file with the Secretary of State, ensuring all documentation is correct, and the partnership agreement should be drawn up between the partners to determine mutual rights and the duties in relationship to the LLP. In some states, LLPs are limited to licensed professionals such as lawyers, doctors, dentists, or accountants. However, the state of Colorado will allow Pete and Paul to organize their company as an LLP without being one of those professional licensed. Colorado allowed general limited liability partnerships to form due to House Bill 1061 on May 24, 1995. And the act significantly changes the partnership law by permitting existing and future general partnerships to register as limited liability partnerships, and by permitting existing and future limited partnerships to register as limited liability partnerships. The principal significance of the registration of a partnership as an LLP, as the case may be, is to provide limited liability to general partners in the registered partnership. The Act also creates a new entity, the Limited Partnership Association. And the filing fee to file for the registration in Colorado is $50. So Pete and Paul have a successful business with Bears R Us as is, and by converting their business to a limited liability partnership, they'll have more protections, easier tax filings, and the business should remain successful for years to come.